Why do we call the government of the United States the federal government when the Constitution doesn't refer to it that way? What is this idea of federalism and why is it important to the health of the republic? And how can you use federalism to protect your rights? We'll discuss all this next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. This is where we read and we study the Constitution. We teach the rising generation to be free. We learn what the documents say. We learn how to use them to protect our rights, our liberties, and most importantly, the rights and liberties of the next generation. You want to find out more, please head to the website, constitutionstudy.com. You can find this video, the article that's associated with it, and please share it. Everything on that website is there for you to read and for you to share. Send it to friends, send it to family, post it on social media. It's all there for the taking. You can ask questions, you can get involved. If you want, you can even donate to the cause and help keep the Constitution Study available and all this content free right there on the website, constitutionstudy.com. We'll talk a little bit more about other things you can do at the end of this video, but right now, let's talk about federalism. The idea of federalism is not new in the United States. The convention to draft the Constitution was called the Federal Convention in its own records. Although the term federal was not used, the Articles of Confederation and the Lee Resolution that the colonies used to declare independence included plans for the new states to work together. Quote, that a plan of confederation be prepared and transmitted to the respective colonies for their consideration and approbation. According to Noah Webster in his 1828 dictionary, a confederation is an alliance, a collection of entities, to unite in a league or to join in a mutual contract or covenant. The newly independent states confederated together on November 15th, 1777, when they joined the Articles of Confederation. So what is this federalism I've been talking about? Well, again, Noah Webster defined federal as, quote, consisting in a compact between parties, particularly and chiefly between states and nations, founded on alliance by contract or mutual agreement as a federal government, such as of the United States. Federalism is the idea of several entities, mostly states and nations, that join together under a compact, a fancy name for a contract. In America, federalism is the support of the compact that is the Constitution. The Constitution not only created a new union, it also created a new government for the United States of America, delegating to it limited powers. At the beginning of the Republic, there was even a political faction known as the Federalists, those who supported the new Constitution and the powers delegated to the new central government. The 10th Amendment confirmed what many Federalists understood about the Constitution, that while power was distributed between the states and the new government, those powers did not overlap. The 10th Amendment states, quote, the powers not delegated to the United States by the Constitution, nor prohibited to the states, are reserved to the states respectively, or to the people. That means today a Federalist would be someone who supports the Constitution, not only recognizing the legal limitations it places on the government of the United States, but the powers of the parties to that compact, the several states. While many in America have adopted the idea of federal supremacy over that of federalism, there are some in the states looking to restore the compact and the balance of powers the Constitution established. There's been a growing number of state legislatures considering bills that push back against federal overreach. Montana and Idaho have considered legislation to review presidential executive orders. Arkansas is standing up against Biden and his Department of Education's push to have biological men compete against women in sports. Governors, legislatures, and even sheriffs in Texas, Wyoming, and Arizona are acting to ban enforcement of federal gun control measures. And let's not forget the sanctuary state movements in California, Arkansas, and Oklahoma. Many claim that these states are pushing for anarchy when what they're doing is upholding the supreme law of the land. As the 10th Amendment states, any power not specifically delegated to the United States in the Constitution generally remains with the states. When those in the federal government exercise powers not delegated to them, they are stealing power from the states. So it's quite right for the states to assert themselves to retain their power. But doesn't the Constitution say that federal law is supreme? Well, Article 6, Clause 2 states, quote, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and judges in every state shall be bound thereby, anything in any constitution or laws of any state, to the contrary, notwithstanding." See, only the laws of the United States made in pursuance to the Constitution are supreme. So when Congress enacts a law that is not within their delegated powers, it's not supreme. Now, according to Alexander Hamilton in Federalist Paper number 78, quote, "There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than the principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men, acting by virtue of powers, may do not only what their powers do not authorize, but what they forbid." The idea that a delegated authority could act contrary to their commission is so absurd, Alexander Hamilton compared it to putting a servant above their master. Rather like those in public service, ruling as masters of the people they are supposed to serve. And Mr. Hamilton doesn't just say that these acts are wrong, but that they are void, empty, and having no legal force. This is not simply the opinion of one of our founding fathers. Even the Supreme Court recognized in 1803 Marbury versus Madison case the supremacy of the Constitution over the acts of the legislature. Quote, "Certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently the theory of such government must be that an act of the legislature repugnant to the Constitution is void." What is true for Congress is just as true for the rest of government. When the president signs an executive order that does anything but direct the executive branch to follow the laws made pursuant to the Constitution, he is acting contrary to his commission in the Constitution of the United States. And since those on the federal courts are bound by the same Constitution, when they ignore its language, their opinion is just as void as the acts of the other two branches. The Constitution does not delegate to the United States the power to define, much less redefine, what it means. That power remains with the states. As part of the Constitution, only the states have the legal authority to define or change the Constitution. That's why the Constitution can only be amended by the ratification of 3/4 of the states. So when a leader in Congress dismisses the restrictions placed on them by the Constitution, when a president says that the amendments are not absolute, or when a federal court finds in a way contrary to the language of the Constitution, their actions are void. It's not anarchy or disobedience for states to assume their rightful powers within the Republic. It is their duty. Article 6, Clause 3 of the Constitution reads, quote, "The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification for any office or public trust under the United States." When your state representative and senator, your governor, or even your state judges take their office, they must swear or affirm in their oath of office to support the Constitution of the United States of America. That includes the Supremacy Clause in Article 6, Clause 2, and the 10th Amendment. They have sworn or affirmed to only recognize the laws of the United States made in pursuance of the Constitution, and to limit the powers of the federal government to those delegated by that same Constitution. So when state government officials stand up against federal acts which are void, they are not promoting anarchy. They are performing the duty they swore or affirmed when they took office to support the Constitution of the United States. The Declaration of Independence states, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." While some people see federalism as a dirty word, it is an important part of the American Republic. It's the states defending their rights and powers as guaranteed by the Constitution. It's the role of the states as a check and balance against the federal power. And it's the protection of your right to consent to the powers of government. As the states have succumbed to federal bribery and abdicated not only their powers, but their duty to protect their citizens, the federal government has grown into the behemoth we see today. Are there things in this modern world that should be done at a national level that are not authorized by the Constitution? Probably. But that is not an excuse for ignoring the supreme law of the land, allowing the rights of the people to be infringed, and allowing the federal government to exercise powers not consented to by the people. If the American people are to return to their rightful position as masters of their governments, it will not begin in Washington, D.C. It won't even begin in our state houses. It will begin with people exercising their consent at the county and city level. Then, when they have regained control of local government, we can begin to restore the states to their rightful place as masters of the federal government. Until that time, this experiment in self-government that has been entrusted into our hands will be viewed as a failure. Whether you've been taught that federalism is a good thing or a bad thing, whether we look at states' rights or you're worried about federal supremacy, the question really is, what is the proper balance of power between the states and the federal government? Now, the Constitution of the United States makes it quite clear that the federal government is only authorized to exercise powers that have been specifically delegated to it by the Constitution. The 7 articles and the 27 amendments. That's it, no more. Anything else remains with the states. So when they go beyond that, when they do things like create an EPA or an HHS or a HUD or a Department of Education or a Department of Agriculture or even a Department of Energy, they are breaking that consent. They are violating the consent of the American people. They are breaking the law. They're breaking the compact. Now, when this country was created, the states had say in the federal legislature. The Senate was meant to represent the states. That's why senators were chosen by the state legislatures, not by the people. Sadly, in 1913, that power was frittered away by the states. They gave up their say in federal legislation for political reasons. And again, in 1913, the states gave up their role as a buffer against the federal spending spree by handing over to the federal government the ability to tax the people directly without going through the states, without apportionment. Now, if that's the problem, the question is, what can we, the people, do about it? And the answer is to return to federalism. Return the republic to a situation where the states have authority over the federal government. The federal government is kept within its delegated powers and no more. And then the people control the states. But you see, after 12 plus years of indoctrination by government schools, most people don't understand. They don't believe that. They believe anything Congress does is supreme law, holy writ, and cannot be challenged by the states. Only the Supreme Court can challenge what Congress says, even though that's not what the Constitution says. Thomas Jefferson said the cure to abuses of constitutional power is to educate the people to exercise that power properly. I'm paraphrasing. That's what we're here to do. We're here to help you understand your constitutional powers, how they apply to the states, and then how they apply through the states to the federal level. Now, there's a couple ways you can do that. Again, you can head to constitutionstudy.com, find these articles, look up topics, see what we have here, and by all means, share them. Maybe you want to have a little Constitution study on your own. We have tools that will help there as well. But the other thing you can do is become a constitutional scholar. Now, I know most of you think, oh, constitutional scholar, that's someone who's gone to law school and has all sorts of degrees. No, a scholar is a student. So becoming a constitutional scholar is merely becoming a student of the Constitution. Head to constitutionscholars.com, sign up for free, and we'll help you learn how to become a constitutional scholar, and we'll help you learn how to study the Constitution for yourself, share that information with friends and family and neighbors, find others that are interested, and see what else we can do to protect the Constitution, our rights, our liberties, and those of our family, especially our children. And if you really believe that's worth your time and worth your effort, if you're willing to put a little bit in, Hopefully you'll also come back here and we'll talk about whatever comes up next right here on the Constitution Study.
There's